And get started. Hello, everyone. My name is Brandon Welch. I'm a managing director here at Incura. Today, we're going to cover the life cycle of a ransomware event through the lens of an insurance claims. We'll cover key areas and decision points for organizations. The goal for our audience today is to learn the financial impacts of a cyber incident at a high level, to avoid pitfalls, and to learn more about the incident life cycle. We'll follow up next week with the slides and a document containing key takeaways from our experts. Should any attendee have any questions at any point, please feel free to ask them in the Q&A function. And finally, any views expressed by our experts are their own and not that of their employer or firms or any affiliated organizations. It is also anything that we discuss today is not meant to constitute any legal or professional advice. We will be recording the session today. With that, I'll go ahead and pass to our experts to say more about themselves and their role today. Next slide. So Dina, you're the one just to the right of me. Go ahead and kick us off and then pass the mic.
Dina Sinergia. I am managing director in the New York office at Incura, and I'm part of the forensic accounting insurance claims consulting practice. So we help insureds put their loss together when they are hit by a cyber attack and walk them through the process and help them submit a claim to their insurance carrier. Laura, want to go next?
Great. Hi, everyone. I'm Laura Nielsen. I'm a Senior Managing Director with Ankara, and I lead our cyber reactive services. That includes incident response, data mining, threat intelligence, dark web monitoring, and expert services.
I
Ken?
guess I'll go next. Oh, Ken, go ahead.
Great.
Mark, I'll let you go first. Go ahead.
Thanks, Ken. We'll save the best for last then. My name is Mark Vozis. I'm a partner in Goldberg Segala's New York office. I'm also chair of the firm's cybersecurity and data privacy practice. I wanted to say a very happy 25th anniversary to all my colleagues at Goldberg Segala, 25 years of moving clients forward, and I'm very proud to be here today. So thank you, Ankara, for inviting me. Ken?
All right, thank you. So good afternoon or morning, depending on where you are. My name is Ken Saw. I'm a partner in the Chicago office of Jackson Lewis. My practice focuses on helping clients prepare for, investigate, and if necessary, defend themselves in the wake of a cybersecurity incident.
Great. Thank you, everyone. Looking forward to the conversation today. Next slide. So this is going to be a high-level overview of our cyber incident lifecycle. We're going to walk you through two of the big areas, from the initial set of facts, this first-party losses, all the way to the insurance recovery, which is where Dina and Mark are really going to shine. Next slide. Naturally, we got to start with some bad facts. That makes a good story, right? So everything was going great until, so the organization we're going to be dealing with today is a novelty ice cube mold manufacturer called Dillon Designs. A couple of weeks ago, an IT manager received an email with the words bonus payment in the subject line from what he thought was his payroll company. He opens the email to find an attachment requesting his username and password to open it. Unfortunately, our IT manager in this case did both. Next slide. The outage. So the day after day zero, our ransomware has deployed. And in this case, it is Crab Rangoon. And the production alarms, we find ransomware notes, systems are unresponsive. What coverage issues are we thinking about at this stage, Mark?
So from the insured's perspective, the coverage issues are how exactly did this come about? What parties are involved? You said it was an IT manager, but is that IT manager employed by the company, an affiliate? Is it an outside vendor that you outsource your IT to? You need to also take a look at your policy and implement the plan that you hopefully have in place, because it's that plan that's going to dictate what steps come next. Contacting your broker is obviously a very good idea because they will hopefully be not only familiar with your policy when others in the company may not be, but they will be able to help you with this process by putting you in touch with the insurance carrier, providing first notice of loss, and getting the ball rolling in terms of the services that your insurance carrier may provide themselves or through the preferred vendors that they have already negotiated with and have mentioned or noted in the policy.
Awesome. And what mistakes do we see companies usually make at this stage? This is for anybody really to hop in on.
I'm glad to jump in there initially. I mean, we often see from an incident response perspective that companies are slow to involve counsel, they're slow to involve their carriers. Sometimes the IT teams try to jump in and mitigate things themselves or cover up the potential situation, and they don't involve the incident response firms quickly enough.
Yeah, and just to piggyback off that a little bit, and I'm sure Mark sees this often as well. But before an incident, we often talk about having strong policies, and I think if you haven't been through an incident, that's just kind of a catchphrase. But it's those strong policies that enforce decision making at this early stage. Is this a low risk that the IT team can resolve internally, or is this a medium high, very high risk that they need to alert someone on? And without those very strong, specific policies, the decision making starts going awry very quickly. And sometimes it's very difficult to reel those decisions back in.
Gotcha. Okay. Do you have an example of those types of decisions, Ken?
Yeah, I think an easy one that we often talk to clients about is having those vendors in place ahead of time. Oftentimes, carriers will have panel requirements depending on your policy, or they may have preferred vendors that they work with that can get you preferred rates. Um, by going to outside vendors, you may be jeopardizing at least some portion of coverage or some benefit that you have to the carrier. When we get on board as privacy counsel, one of the first questions we ask is, well, are these vendors that you've worked with before? Are these vendors that your carrier has approved? Not because we can give them coverage advice, but because we don't want to switch horses midway through an investigation.
Great.
I think those are excellent points that Ken just made. And I just want to highlight that preferred providers that insurance companies vet and allow the insured to choose from, not only are there negotiated rates there typically, but also these vendors have a demonstrated ability to handle these types of incidents. Many times, some of the mistakes that are made by companies are using just an IT company that someone knows, someone's cousin, brother, uncle, sister, aunt, some kind of affiliate. These are not necessarily mistakes, but they may not be the best people to respond to the incident. And as Ken mentioned, it could jeopardize coverage under the policy for the costs that are going to be incurred.
Good point. All right. What should the company do at this stage? This is for everybody. We should all say this in unison. Contact your insurance company. Contact your insurance carrier. You have to reach out. Mark, do we jeopardize coverage when we don't contact our insurance carrier?
It always depends on what the policy says, but typically I would say that it's not a best practice not to contact your insurance carrier when you have an incident. Many times the insurance policy requires notice within a certain period of time, but even if that notice period has not run, the issue is going to be which services and which expenses can you incur without first obtaining the insurer's consent. That is a big issue. And it's one that really is pretty easy to make sure you don't run afoul of. Involve your carrier. They have experience, much more experience than the company that's suffering the incident. And many times can actually point the company in a direction in terms of vendors that are actively remediating the same type of incident. So to best posture them in the best position to recover quickly and with the least amount of disruption.
Great answer. All right, let's move on to the next slide. We have reached out to the insurance carrier. We have now called up Ken and Laura to help us as the company through this incident. What are you guys doing on this stage when we first hop on the phone? Walk us through what you're thinking through, how you're helping us out.
Yeah, maybe I can get started a little bit and then hand it over to Laura, which is, I think, how this call would go anyway. The first part of incident response is making sure we're protecting privilege. And a lot of times our clients, they see the immediate need, which is to get back up and running and complete the investigation. And they think of privilege as an abstract issue and might not be top of mind. But if there is a regulatory investigation, if there is a class action lawsuit, you're going to want the protection of privilege for these discussions. So we set up a tri-party agreement between ourselves, our clients, and Laura to ensure that we can have candid discussions about the investigation, about what's going on in the environment, and any steps we may need to take. So I think that's the first thing we try to explain to clients. The second thing we try to do is explain the entire life cycle, which is a bit much, admittedly, because again, clients are thinking, what do I need to do today? But at least the senior decision makers need to understand the full life cycle, the big picture of where we're trying to go. Not in detail, but over the next 1, 2, 3 months. Here's what we need to do in the context of all your decisions. Having said that, now let's talk about the next 1, 2, 3 days. So we try to give them context and then zoom into the decisions that we can make today. And oftentimes that's helpful in alleviating at least some of the concerns. You can't change what you can't change, and focusing everyone in on the things that we can change. Then we would turn it over to Laura and say, okay, now we need to understand what's going on in your environment. And Laura's going to ask you some questions so that she's able to prepare her team.
Absolutely. So making sure, to Ken's point, that counsel is always involved and that they're on those initial discussions and every subsequent discussion. The initial discussion for us with counsel looks like a scoping discussion. We really want to understand at that point, what does the timeline look like? What has the IT team or others within the environment identified? What have they already done, so that we're avoiding duplication, and also so that we can help to coach and guide the IT team from potentially taking missteps on their own that might impact the investigation. We're really trying to ask specific questions like number of systems and endpoints. What does their environment look like? Is it Windows? Is it Linux? Things that are going to help us as we start to prepare that statement of work and give them a very tailored next steps outline for what the forensic investigation is going to entail. At that point, we're going to put that together. We're going to include counsel in that process and the tri-party agreement, as said. We'll give an estimate of cost. Cost often varies depending upon the size of the organization, what the potential incident looks like, what that landscape is. It can be thousands of dollars to hundreds of thousands of dollars. But those are the first initial steps that we have to get through from a scoping perspective.
Wow. Sounds like insurance would be helpful there. And kind of on that note, Mark, what is insurance doing at this stage?
So when we think about insurance at this stage, it's two sides, right? There's the policyholder side and then the insurer side. On the policyholder side, they should be reviewing their coverage to determine how much of the expenses will fall within the retention versus that which will be covered. They should be looking at their insuring agreements to see which first-party coverages apply, whether or not they have sublimits, whether or not they have aggregate limits or separate limits for coverage sections. And on the insurer side, it's somewhat similar. Really looking at whether or not the insuring agreement has been triggered, looking at the retention, looking at available limits, but also trying to get estimates from the vendors that are involved in terms of what they estimate the cost will be so that there can be a good cost management of what's going on. That's for the benefit of the policyholder, just to make sure the policy limits are not run through and to make sure, based on the experience the insurer has, that they are looking at this from their vast experience and saying, okay, well, you're saying it's going to cost $500,000, but really in these cases, what we're seeing is something in the range of 100 to 150. So there can be a discussion on that. It also can reveal instances where a non-approved vendor is being used. Some consent issues can be worked out and can validate whether or not the team that's put together is appropriate for this given event. In this scenario that we're dealing with here, we're dealing with a business email compromise. So you want to make sure that your team that's in place has experience with that and that they're addressing it appropriately. That we're thinking about, okay, well, what's coming down the pike? We're going to have to probably have maybe data mining. What is that going to involve? How large is the sample? And I'm sure that Laura and Dina will talk about that a little bit later on. From the insurance perspective, we are also thinking about how best we can assist the insured in recovery. Are there other issues that we need to discuss, such as, is this a business email compromise, which I sort of alluded to earlier, this IT manager that clicked on an email, whose system was the email on that then spread to the insured system? Was it a vendor? Was it an outside server? Was it some other third-party service provider that you want to basically unpack to make sure that the systems that are affected are covered by the insurance policy? And if it is another party that's involved, how can you coordinate with their response to this event?
Wow. I think you hit all of your marks. Mark, nice comment. Very thoughtful answer. So we do have a question real quickly. Beth Thornton, can you address the issue of engaging approved vendors through your organization versus having your outside counsel engage the approved vendor on your behalf? I think that's over to you, Ken. I think we chatted around attorney-client privilege, but if there's anything else that you can throw in there, please.
Sure. I'll just preface by saying there can be ideally vendors that are on both lists. And I think that's where the preparation part comes into play. I think everyone on this call gets engaged at some point for either a tabletop exercise, an incident response planning review, or some sort of privacy risk assessment where we're looking at vendors you may engage for a cybersecurity incident. That planning helps you identify the vendors that you may want to put on that pre-approved list for your internal purposes as well. Having said that, that's the ideal. And of course, these are sometimes unexpected incidents. I think, one of the things that we really worry about, and something Mark touched on, is you want to make sure that you are engaging the right team from the right place for the right incident. And you may have a fantastic vendor who provides, let's say, an EDR solution for your team, and that's what they're engaged to do, or they may be an MSP and they may be great at that. But that's a different skill set than investigating an incident. And so we often have to have kind of uncomfortable discussions about very specific experience when clients want to engage someone that they may be more familiar with in different contexts and what the difference may be. So that's maybe on a more practical perspective. From the attorney-client perspective, courts have been very clear on what they will consider privileged and the arrangements you need to have from an engagement perspective. So you may have a great team with the right people and from the right vendor, and they may already be in your environment and be familiar with everyone. But if we don't engage them in the proper sequence with the proper engagement trail, all of their work will not be attorney-client privilege protected. So we try to make sure that we at least lay out our preferred method of engaging vendors to protect privilege for clients. Ultimately, as outside advisors, we can only advise you. This is what we would do. This is what we would recommend. This is how you protect privilege. Clients sometimes say, "Look, I understand all of those things, but I still want to go with my firm," and that's ultimately their decision. I will say in those instances, we're very careful to document that we've laid out the issues and the client's made a decision. So hopefully that answers the question.
Great. Thanks, Ken. All right. Next point. What coverage pitfalls are common here? What sort of issues do we see organizations make or during this time? Mark?
So I think we've already touched upon the notice issues, not using approved vendors, not getting the insurer's consent. I'm going to now move on to a pitfall that I see happen all the time. And this is a plug for Anchor, because you need to get your forensic accountants involved if it is on a large enough scale that it is disrupting your business operations. Why do I say that? Because when you get someone like Dina, or Laura, or Brandon involved early on, they are going to be in the best position to tell you how to document your impact. And that's very important, because many times you cannot go back and figure out what was done and what the costs incurred relate to. What do I mean by that? incurring expenses on trying to get things back up and running. Hiring people, whether or not that's covered is debatable under the policy terms. You'll have to see what your policy provides. How about overtime? Well, maybe, but not if you don't provide records saying who is involved, why were they involved, and what did they do on that given day for the hours that they worked. And the Ankara team is going to be able to help you through this entire process and really get you up to speed so that you are best positioned to account for everything that you are going to put in your BI loss. So with that, I'm going to pass it back to you for the next question because I think that is a natural flow.
But you may have even taken a bit of Dina's thunder. Dina,
I
are you
mean,
involved yet? What's going on?
all good. Yeah, Mark just took my answer, but yes, obviously getting your claim prep team, forensic accountants involved as soon as possible is always, highly recommended. We can get involved at any point in time during a claim, but when we're involved from the beginning, we're listening to the conversations you're having, with your insurance broker, with the coverage counsel, with your carriers, and understanding what business decisions you're making, right? We're talking about a manufacturing facility. Do you have two locations? Can you shift production to another one while one is potentially down as a result of the cyber attack? What are those extra expense costs? So we're in the background listening and taking those notes. And so as we will get to later, we're putting a rough order of magnitude together and helping you think through things, right? We've done hundreds and thousands of these claims before. So we might ask you these questions. Can you shift production? Can you add a third shift if you're only running two? Can you do all these things to try to mitigate your loss? And if the answer is no, that's okay, but we've thought it through. And you can tell the carrier, hey, we can't do X, Y, and Z, but we can do A, B, and C. What are the revenue streams being impacted? So we're just helping understand all of it and advising you track everything, right? You're going to send notices to your customers. Customers are going to be emailing you back. We want you to make sure you're documenting all of that. So it's really just involving in the conversations so that everything, you just have an idea of what you're looking at and helping make smarter decisions as you go through the process.
Awesome. It sounds like it actually is cheaper and easier to bring you in on the front end rather than on the back end to unwind everything. Does that sound right, Dina?
Yeah, usually so, because when we're involved at the later stage, or if you just kind of, as Mark said before, there's two sides to this, the insured and then the insurance carrier, right? And the carrier is going to hire their own set of forensic accountants to ask all these questions as well. Ideally, we're both involved at the start and we can work in tandem to get everyone the best result possible for each side. But when we're trying to come back and if you're saying, we got a number from the carrier and it just doesn't feel right. Well, now we have to try to understand what you did, how your business was impacted, and unravel just the mess and chaos of what's been done. Where if we're involved in the beginning, it's just we can help streamline the process. So yeah,
Awesome. I didn't never knew that forensic accounting was a team sport. Sounds
it
very
can be if
cool.
it's done right.
All right. Awesome. Well, next slide then. The incident response. So Laura and Ken have dug in. They've begun looking at things. Unfortunately, the domain controller has been compromised, and there's potentially a data loss at issue. All right, Laura, Ken, what are the issues Privacy Council and the incident response firm are concerned with at this stage?
Yeah, I think this is the part where we start asking, what data are we really talking about? What do you have internally, generally speaking? Are you able to circle the wagons around the data that was actually impacted? And do you have any insight into what that data looks like? Sometimes the answer is no, and that's okay, especially in the beginning of a cycle. But the real goal is to ultimately try and understand those questions so that we can advise clients on your legal obligations. So a lot of legal obligations are driven by the answers to those specific questions. There may be other steps we take to shore up that response, but having that initial guidance from clients is immensely helpful. So just kind of give you two examples that let's call them hypotheticals, but are common. Sometimes the data that's impacted while valuable in one sense, is probably useless to anyone else in the world. So it could be like uh, sales data for this type of ice cream from this store. It's very valuable to that store because it helps certain thing make business decisions, but that's not going to drive any kind of legal obligation. So we may give different advice than if a client were to say, well, this is actually our CRM database where we keep all of the PII for our entire company. We're not sure what happened, and we're not sure what's been encrypted and what's not, or exfiltrated and what hasn't. Then the advice starts to look very different, and the way we work with Laura's team will be very different. So I'll hand it off to Laura for the next part.
Yeah, I think beyond, the initial scoping questions that the incident response firm asks with counsel and the issues that Ken just raised is really about what are the immediate actions to take. And as we all understand, and we want to have coordination up front with all parties, there are also some really immediate actions that have to occur to help mitigate the situation. So obviously we are kicking off the investigation. We're likely encouraging the deployment of an endpoint detection and response tool, or we're using a tool that the client already has installed, really to help contain the environment, to isolate any malicious processes that are propagating across the network, right? Really trying to help first set up a secure situation within the client's systems. We're immediately checking the status of clients' backups. We're talking to them and asking those questions. Oftentimes now threat actors are hunting for backups and destroying them before maybe ransomware is deployed. So we want to make sure that any offline backups are secure. We're going through a process of trying to eject the bad actor. We're really looking to secure digital identities, removing any persistent access points, and then remediating those vulnerabilities that led from compromise in the first place. So there are a lot of quick actions that the incident response firm is taking as they're going through sort of the questions and discussions with privacy counsel on the call. The other things we're doing are preserving evidence and making sure that the client is aware of what's necessary for our investigations. We need particular sets of logs to understand patient zero. We need to know the entry into the system and really be able to investigate that based on what the client is preserving. We talked about the pitfalls that sometimes the client or the IT firm might have. These are things when we're in there really quickly, first day, second day, after the incident has been identified, we can help to mitigate these situations. Also, depending upon what forensic investigation has determined, as Ken said, based on the access to information that may have been exfiltrated, we may have further discussions. If there's a legal obligation around the content of that data, if it maybe contained PII or GDPR governed data, then that's going to be a next step discussion into data mining.
Yeah, I think some really good points Laura brought up that I skimmed over initially. But I think part of what clients struggle with during the investigation is knowing what to prioritize and how to prioritize these initial steps. Because again, they want to get back up and running, or they want access back into their email environment, or whatever it takes for them to resume normal business operations. That's the next thing they want, and rightfully so. As business folks, that's their focus. But oftentimes we have to work with the forensics team to advise them on why we may need to do certain things in a certain order. So EDR tool is a great example. That's a sometimes quick exercise, and sometimes that's a time-consuming exercise. And it does sometimes bring frustration into the room because they may be getting advice from others who say, no, I need to get the endpoint tool on today, and I need to do that because I need the register to start working. And that may be true for that very specific issue, but it's going to slow down the investigation overall, which will slow down the process of getting the full business up and running, and also slow down the investigation, which determines your obligations.
Awesome. And before we get into data mining, Laura, we do have a question from an anonymous attendee. How easy is it to change legal counsel if the insured isn't satisfied with the assigned counsel support? I'm going to look at this in two ways. One, from a physical change of horse, so to speak, midstream. So moving from one approved counsel to another. And then two, what do those conversations look like? More for a question for Mark to try to get unapproved counsel confirmed for this particular incident. Ken, we'll start with you.
Uh, I think like most counsel, I've probably been on both sides of this. I've been the counsel that started, and for whatever reason, the client doesn't feel like it's working out. And I've also been the one that's getting the call saying, "Oh, our counsel's not working out." And I can say I don't feel better or worse in either of those situations. It does raise some challenges for your counsel, regardless of if you're being substituted out or in. And most of that has to do with maintaining consistency. So, ultimately, of course, there are relationships, and you want to feel very comfortable with the counsel you're working with. Um, but substituting counsel to get different legal advice could actually harm you long term, and most attorneys will advise you of that. So that's the first thing we talk about when an existing client calls and says, "Hey, we've had an incident, and we started with someone else, and we want you to sub in." I can't give them inconsistent advice because that would put them in a worse off position overall than whatever advice they feel is not meeting their needs. So I think that's the first thing to think about. From a practical standpoint, can we be subbed in? Can we sub in for others? Yes, we've done that again on both sides of the equation. And if it is kind of in this system that we are all more familiar with, so if it's vendors we've worked with often, so like Laura's team, we've worked with them often. So if we were to be substituted in and they're in place, that obviously makes it easier because we know their playbook and they know our playbook. Oftentimes we have relationships with the counsel we're replacing or the counsel that are replacing us. That also makes it easier because ultimately we're really there for the best interest of the client.
So
Awesome.
taking a look at this from the insurer's perspective, it happens. It happens. But let's parse this out into two separate viewpoints. Number one, you have insurance. Number two, you don't have insurance. Let's talk about you don't have insurance. You can do whatever you want. You can swap out your counsel. You can get another attorney in there if you want. It's your choice. The client drives the relationship. We'll leave that there. The insurance. You want to swap out, a discussion should be had. And then with respect to both scenarios, you come back to the next point, which I'm going to make. What's the problem? Is it a substantive issue or is it a chemistry issue? And it might be another issue, but chemistry and substance are typically the next level of the analysis. So the question is, how easy is it to change legal counsel? Well, if it's chemistry, it's pretty easy because there's going to be a consistency in terms of the level of legal service that's been provided, the substance. And if the substance is fine, then counsel that's coming in can just pick it up where the outgoing counsel left off. But if the switch is being made because of a substantive issue, then I think it makes, and Ken can opine on this, it makes it a little bit more difficult for the counsel coming in because they cannot rely on the work that's been done by counsel previously. And I'll let him get to that in a minute. Now, with respect to swapping out the counsel, you're also going to have to understand that there is a learning curve, and it depends on how far down you are in the process and what stage you are in the recovery. Let's say you are at the inception of the engagement. Well, counsel may not have done as much as if they're 6 months down the road or a year down the road and there are regulatory investigations. And now you're going to put a different counsel before the regulator and tell them, oh, we've been substituted in for the prior counsel. And then what kind of red flags does that raise? Is that something you want to do? So Ken, I'm going to put it back to you to maybe discuss whether or not what I'm saying is accurate from your point of view and whether or not it is more difficult to take over when it's a substance issue.
Yeah, when it's a substance issue, Again, whether we're being substituted out, so whether we're the outgoing counsel or the incoming counsel, the discussion on substance is really the same. And what is it that you either disagree with as a client or don't feel it's meeting your needs? Um, there are rare occasions we have not been involved in either way on ones where the legal advice is just not correct, and so that those things do happen. But if you do change counsel based on that substance, I think there may be a difficult track record to defend. So I'll just use a very easy example because it might be one others can understand. In highly regulated industries, and I'm going to talk about like banking regulators, one of the highest regulated industries, when you notice an incident like this, they're going to dig into what happened more so than maybe a state attorney general will. And that's their function, that's their legal function. Part of what they're looking for is to understand systemically, is there a problem? So is the banking system at risk? Is part of the banking system at risk? Is your bank at risk? Is this person's account at risk? So, there are these different levels of risk analysis. The other thing that goes into that is your reaction to the incident. So that may not even be necessarily, did you follow the exact law? It's, did you, as a covered entity under this regulator, react to an adverse event in a way that they expect? And two banks can come to the exact same conclusion, and the regulator can decide, I don't like the way you reacted to this. So what happened here? And they can start to ask some uncomfortable questions. So I think in those kinds of instances where you're trying to defend switching counsel, you have to have really good explanations. And even as counsel, it's been substituted in for those situations. We have to work really hard with our clients to make sure they understand that. And it's not just, you substitute us in and then we wipe the board clean. We have to work with the record that we have. If clients feel, and they can feel earnestly that that's the best choice, then we obviously advocate for them the best we can. The other situations we've been in, sometimes we get engaged to just help. And I think that's more maybe the chemistry issue, Mark, you're talking about. If it's just not working, but they know that the legal advice is good, just to help translate sometimes can be helpful, or just to have a third person in the room can be helpful. And so we try to encourage clients to avoid substitution when possible.
Awesome. Yeah. A quick comment from Cesar Cabena. His experience, or their experience, is that counsel replacement usually causes delays. I think we've all seen that. I'm being thoughtful of time. And Laura, you were right at data mining, one of my favorite topics ever. If you want to go ahead and kick us back into the topic itself before we get to the overall cost of incident response.
Absolutely. So as we're going through the incident response investigation, if there has not been specific data that was identified for access or exfiltration, if the IR team couldn't narrow the data sets, sometimes Privacy Counsel will assess the potential legal obligations based on the type of data that was accessed. If it was HR data, if it was health records data, if it was other potentially sensitive data, data mining will be recommended. One of the pitfalls that we see here often is that clients will maybe try to do their own data mining in-house. They'll say, we understand this data. We know exactly what's in these files. Or they'll assign a group of employees to go through the files and try to pull out names and sensitive information. We see that costs company resources. It takes additional time. And one, it puts the companies in a really potentially uncomfortable situation with regulatory scrutiny. When they have class action litigation, it throws them into a harder position than they realize had they just used a services firm like Ankara that does data mining for thousands of clients. So data mining typically involves a really programmatic approach to identifying which files have PII or PHI or FERPA or some other regulated data. We go through a culling process to remove false hits. And then it also involves manual review by active team members. Ankara and others have been using AI and platforms built on large language models to help reduce the manual review burden that this often puts on the timeline and the expense. So that can reduce the overall timeline as much as 80 to 90% if we're using AI tooling to help identify and pull out sensitive content. We always put live auditing manual review team members on top of that to ensure accuracy of the information that's being pulled. And then what that ultimately looks like is a concise, consolidated list of individuals whose information was identified in these data sets. That might be their names and addresses and social security numbers, or it might be other types of sensitive content. Maybe it's passports or medical information. If we're under GDPR guidelines, it might be something as broad as their religious affiliation. So our teams in data mining are taking direct guidance from Privacy Council on what we need to obtain in the data. And then we're pulling that into a really consolidated format for potential notification down the line.
Awesome. So Patrick Wilson, self-data mining is a real bad idea. They're not experts in forensics. And what if a gap was missed and found during the legal discovery, impacting customer that holds that liability? Mark Vela has a question. Any commentary on difference in industries who have been breached? Tech firms v. financial firms versus healthcare versus universities. Looking for thoughts on level of experience and technical skills and how that impacts the outcome of this event. I know that's a lot, but again, being mindful of time, we have 19 minutes left. Let's keep this train rolling. So quick thoughts, Ken, Laura.
I'll jump in with one quick one. We see them across all industries. And honestly, whether it's educational institutions that have to be responsive to FERPA and other requirements, or have systems, maybe municipalities that have outdated systems and keep 20 years of information in their archives, we see across every industry that there's usually large volumes of sensitive content that the client themselves didn't actually think they had in their systems.
Great.
Bella, that was a great question. And I really like the distinction between these different types of industries. And I will tell you that healthcare and universities maintain a lot of information they don't even know they have because they're always trying to get donors, number one. Number two, they don't have the staff to help out when a breach occurs. And they're probably in the not best position to assist themselves, which is why Laura is the person to go to try and figure out exactly what was taken, because they just don't have these industries, universities and healthcare don't have the budgets.
Great point. So just wrapping up this slide very quickly, I'm going to ask each one of you, what are the typical costs? We've all seen the bills come in. What do you see for these types of incidents from back or from front end to the end? Dina, let's start with you. You've done a lot of these things. What are the typical costs you see for incident response?
I mean, it for sure ranges. And I've seen a lot of invoices, and now it's probably Laura's probably is the better person that it's more her invoice that is being looked at. So more Laura, give you that floor.
Yeah, I'm going to say again, it depends on the type of incident. It depends on the client. It depends on their industry. Again, to the amount of data and the type of data that they're holding, and then ultimately on, some of the regulatory responses that they're going to have to deal with. Hundreds of thousands of dollars certainly is sort of an average, definitely not the max.
Okay, next slide. Ransom and ransom decision. Whole webinars have been done on this. We are going to try to get through this in 5 minutes. Yeah. So Ken, Mark, what are organizations thinking through when they get that ransom? How are they making that decision to pay or not to pay?
Yeah, I think initially a lot of the discussion is about whether they need to pay. And it's obviously a very broad question, but it leads to really important discussions about the viability of backups, the testing of backups, what it might even take to get the backups back up from wherever it's stored. So if you have backup sitting next to you on your desk, that's very different than if you have to drive 3 hours to your offsite location. The other discussions that continue to come up in the context of whether to pay or not is whether it's going to be quick if you pay. And this is I think, an important point that sometimes gets lost. Organizations think, well, if I just pay, I'll be back up and running tomorrow. And that's a long discussion that has to be had about the sequence that's necessary, even if you pay, to get your organization back up and running, and what it might take once you do pay. And so I think, things we talk about are actual timelines in either direction, whether one is viable and not or not, the value of the data that was taken. So whether it's social security numbers for everybody in your company versus receipts for the last month, they have different value. And then separately, if there are other kind of non-legal issues we should know about, and these are kind of consequential issues, like consequential, I don't mean it as not important, but from the legal context, not legal drivers. So you may have some reputational issues you're concerned about if some of this data were to become available on the dark web. So those are the things, very unstructured list, but in 5 minutes.
There we go.
Okay, so
Mark?
I'm going to jump in here really quick because we're really running out of time here with the remaining slides. What I can say is this. Number one, who's going to make the payment? Why are you going to make the payment? Are you paying to get the encryption keys because you need it to get operating again, or are you just suppressing the publication of that information? Does your insurance policy even cover suppression? Do you want to make the payment? Because that's going to reduce the amount available under your insurance policy, which means that everything that's going to come after this, notification, credit monitoring, potential class actions, additional notification, regulatory actions, that might not have coverage. And then at the end of the day, can you even make the payment? Who are the threat actors? Are they sanctioned individuals? Are they on the OFAC list? Has that been searched? It might be that you can't even make this payment because it's precluded by the government, by laws. So you're right, Brandon. Their entire webinars have been devoted to this subject.
Exactly. And so here's a fun question for everybody. What have we seen personally for average ransom payments and demands? I've seen as small as 4 figures and up to 8 figures. Personally, I've heard rumors of 9-figure ransom demands. But Dina, you do the paperwork at the end of the day. What have you seen?
Yeah, I mean, I've seen that range. I mean, that you just said, 4 to 6 figures is just, again, depends on the insured and who they are and what kind of data they've got.
Awesome. Ken?
Same, I think high 5 to mid 6 ranges are, I don't want to say typical, but what we see on a frequency basis. Certainly initial demands have been creeping up to the it's 7, 8 figure range, but it really is kind of all over the place.
Okay. Well, next slide. Recovery. How does insurance help with recovery, Laura?
Yeah, absolutely. Sorry, finding the mute button. Insurance is critical when we're talking about recovery and needing to involve your insurance carrier. I know Mark can talk about this from a cost perspective. Companies like Ancora can be deployed on the ground to help with recovery, restitution. Often that might require people to be in multiple locations. There's certainly cost involved and a lot of questions with regard to the necessity of having people there. How quickly do we need to get you up and running? Some of the other considerations that we would want our clients to really talk through with their carriers as they're engaging a firm like ours to help with recovery.
Awesome. We do have a comment from Wendy McAfee. If the attack has already occurred and they have the data, it would seem you wouldn't want to make the payments. In some cases, you may still want to make payments. Mark made mention of this of something called suppression. The idea that they would go ahead and delete the data that they've stolen. Data is an asset, though, or at least in my experience. And in some cases, you'll find that though payment for suppression has been made, the data will pop up 6 months, a year later. It's still based on whether or not your insurance policy would allow for that, one, and then two, whether or not you'd want to move forward with it. So I think there's still quite a few things to go through that. And again, lots of webinars around this specific topic, lots of materials that can help you through that thought process. But Mark, what are some insurance pitfalls for recovery, and what are the typical costs you've seen at this stage?
I don't think there are typical costs. It's wide ranging and very specific to the insured as well as the impact of the incident. Insurance pitfalls, I think everything that I've mentioned already, they're just repeat themes, not involving your insurer, not getting consent, not looking at what your policy provides. This is not a situation where you don't have guidance in terms of what is covered. It's written right there in the policy. So working with folks that have experience with handling these types of claims like you guys will make the insured's life much, much easier in the long run.
Nice. Okay, great. Next slide. Customer notifications. We're finally at the end of our data security incident, and notices have gone out, class actions come in. Ken, how does insurance work at this stage? What are the conversations that you're having with Mark and the carrier?
Yeah, so we're talking about the stage where the letters have already gone out.
Yeah.
And now we're just trying to get our arms around, well, what happened? This is probably the first point where clients can actually take a little bit of a breath collectively. The big rush is to get notifications out. We've made important decisions. They probably have recovery ongoing at this point. So from our perspective as privacy counsel, we're trying to summarize the event as we understand it, summarize the incident as we understand it, the key decisions that were made, so that we can document that the clients have made all their legally required notifications. I think there's a little bit of a tail that will go into the next panelist, which is, well, now what? What do you do with these the costs that you've incurred, and how do you actually get back up to where you were from a financial perspective?
So, yeah. And just to kind of tie this off, do we have a sense as to what the average cost for a data breach class action lawsuit looks like? And this can go to anybody on the panel. I know I've been affected by them and have been offered compensation, but what does it look like from the vendor side, right? How much do these things cost organizations when they come in?
It's a lot of money, folks. Like between counsel, depends if you're going to get a motion to dismiss, how many times they're going to amend the pleading, whether or not there's any merit to the claim, whether or not it's PII versus PHI versus confidential information. How I was going to say how greedy plaintiffs' counsel are, but how much their expectation is to be compensated for the efforts that they put into bringing the lawsuit on behalf of the class and enforcing what they view as their clients' rights with respect to that data. So it varies wildly.
Awesome. Ken, any thoughts?
I just agree with Mark. It varies wildly. It's also very disruptive to your day-to-day operations. Many class actions are not just a paper exercise. You're going to have to pull in a lot of employees, at least initially, to interview them and understand what facts we may not even be aware of at this stage.
Okay. All right. Next slide. Financial recovery. We're going to shift to the financial impact and accounting. Next slide. Dina, claims preparation. You want to walk us through what a rough order of magnitude is and what we're doing here?
Yeah, we can go to the next slide too, because we put up an example of what a rough order of magnitude would be. This is a ROM. This is getting your arms around what you think could be the loss, right? So the hacker got in and they disrupted your, not just stealing data, but they were able to pause your manufacturing system or anything that now you're unable to do your normal everyday business. So what are your potential losses, right? We're going to have the breach response and Laura's going to give you an estimate for her fee. So we put a high-low estimate together. The extortion expense, what is your potential business interruption impacts? How long do you think you're going to be down? And none of this is meant to be facts. Like it's what you know at this point in time. No one's going to hold you to these numbers and say, well, you were wrong. You estimated wrong at day 2, and now it's day 50. How did you not know? No one's expecting anyone to have all the right answers. But this ROM just starts helping you walk through your loss. What are the potential costs that you might have to incur? Additional payroll. Does your policy have payroll coverage? What are your sublimits? Because all of these line items and buckets of coverage in your policy could be sublimited. And when you're making these decisions, is your extortion sublimited? I can't say I've specifically seen that, but it could be. And these policies are changing regularly as the whole cyber attack world is changing. So it's just putting a handle on what do you think this could be. It gives you a range of high to low of where this claim can come in. And this will help the insurance carrier set their reserve and also start giving advance payments if possible, right? You're starting to be out of pocket costs. You want money to be flowing. So this ROM gets updated regularly as you get more information about the claim and what your impacts are. And something Laura mentioned before about, trying to data recover anything yourself. If you're using salaried employees to do that, that's not an out-of-pocket cost. So the carriers are not going to pay you for salaried people to do extra work. So it is always, it's another cost in the policy that you have coverage for those types of outside expenses. And those are why you kind of go through this ROM exercise to understand what is being impacted and where those costs fit into these buckets.
Great.
And yeah, that kind of gets the overview of the rough. Again, it's a rough order of magnitude. TBDs are okay, and they just help you not forget things, right? If you're like, oh, do we need to put in additional cyber audit procedures? And maybe at the end of the day, you don't, but it's always going to be on that question list of going through it. Hey, do we have any costs for this? Nope. Okay, we can move on. And then as you finalize the claim, the TBDs can drop off if it's not going to be an incurred cost.
Awesome. Any points on this before we move on to our last slide? Great. Next slide.
All right. And again, you can go one more ahead because it's the same questions, just a business interruption example and business interruption in less than 2 minutes. Awesome. Which is probably for the best because getting into the accounting details is way too complicated. We could again do whole day seminars on how to calculate business interruption. But here we just use the example of a couple of different product lines being interrupted for a shutdown period, and then the partial reopen where you got your systems back and now you have to ramp up your business. And typically that is all covered, but again, every policy is different. So here you're kind of looking at historical or budgeted financial data. What would you make if this loss did not occur, if your systems were up and running? Did you offer customer refunds, additional free shipping, expedited shipping, whole slew of things to try to get you back up and reimburse you for the revenue that was lost during this shutdown? So it's the projected revenue less your actual revenue, less your saved expenses. In a production facility, it'd be a raw material cost, right? If you didn't make the product, you still have the raw materials sitting at your warehouse ready to make products at a later date. Or if those raw materials are food-based products where there's spoilage, that would also be part of your claim.
Awesome. Next slide.
That's
it. Thank you. Any closing thoughts from any of our experts today?
Well, from my perspective, I think if anyone has a takeaway from the insurance perspective, it's look at your policy before an incident occurs, have your team in place, know the numbers of the people that you have to call, lean on your insurance company to assist you. They've been through this before, and hire capable vendors, because unless you have folks like those that I've had the pleasure of being on the panel with today, you could be going down the wrong path and jeopardizing insurance coverage.
Ken, Laura?
Similarly, I think the planning is really important, and we see that more and more. Even though data incidents make the news more often these days, it doesn't seem to motivate clients to plan more, and that's sometimes frustrating. So we always try to emphasize invest a little bit ahead of time, get that initial planning done, and that will help you prioritize the thousands of decisions you'll have to make if one of these things happens to you.
Yes, we would absolutely agree. And we tell our clients often engage with your carrier, engage with privacy counsel, and then engage with the experts. And really, I think the combination of doing those things right away, as soon as there's even the potential idea that you've had an incident, will help you in the long run.
Echo
Yeah.
all the comments, meeting with your broker, looking through your insurance policy, understanding where you have coverages, where you don't have coverage. And those sublimits are key to understand, and it does help make decisions and adjust expectations. And depending on where you are in your policy cycle, can you edit that policy today if you have the incorrect sublimits? And make changes, or at least for the next policy period, you really want to make sure you're going to be covered for what your expectations are, right? There's a price for every sublimit, and if you increase that sublimit, you're going to increase your price. So everyone's risk appetite is different, but it's making logical decisions for your company and documenting those decisions so everybody remembers later when the loss does happen, why those decisions were made.
Awesome. The only thing I would say is buy enough insurance, work with your broker, work with your coverage counsel. They'll help you understand what that may mean. So with that, really appreciate all of our experts today, participating in this panel, going through the life cycle of incidents through a claims perspective. And again, we'll be sending out follow-ups with the slides as well as some key takeaways next week. Thanks for your time, everybody, and have a great day.
Thank you.
Thank you.
Thank you.